Hello, I'm Professor Russell Sandberg, and it was a pleasure earlier today to join the National Celebrants Convention to talk about possible marriage law reform. So why then is marriage law in need of reform? Well, the current law, found in the Marriage Act 1949, is now hideously out of date. It makes a distinction between weddings according to the Church of England and all other legally binding marriages. And that other category is very small. So it includes Quaker marriage, it includes Jewish marriage, it includes religious marriage in a place which has been registered as a place of marriage, and it includes civil ceremonies conducted by the state. All other weddings are outside the scope of the Act. So if you have a humanist ceremony, if you have a religious ceremony which isn't in a place of worship, if you have a ceremony on the beach conducted by a celebrant, all of those ceremonies are not legally binding, which means unless and until you also go through the legally binding ceremony, typically in the registrar office, the ceremony, you are not married in the eyes of the law. So this is a big problem because we've now got a huge number of wedding ceremonies whereby there are no marriages, legally speaking, taking place. And so the current law leads to discrimination, it leads to inconvenience in terms of who says that their wedding day is the best days of their life, in terms of there needing to be two ceremonies, not one. And so for a number of years, there's been a number of calls for reform of the law. And indeed, humanists have led that call for reform, and there has been a number of parliamentary debates, and in 2020 there was a High Court decision which said that the current law was discriminatory on grounds of human rights, but justified because the Law Commission were at that time looking at the Law Commission being the body which looks at areas of law which are said to be in need of reform. So the Law Commission eventually published its report, its final report, in July 2022, and we're still waiting for government action in response to that. And the important thing about the Law Commission's report is that it recommended that England and Wales follow their neighbouring jurisdictions, in that we move from a system that largely regulates buildings to a system that largely regulates people. And so central to the Law Commission's proposals was this move to an efficient system, as they called it. And the idea would be that there would be a tightening up and stricter rules at the start of the process, where people go to the registrar to see if they're able to be married. So we'd tighten up the rules there and liberalise the rules in terms of the ceremony. And the Law Commission said they would be open to the government of the day to then determine which officiants could be included in this. Obviously, it would be civil registrars. Obviously, it would be existing religious officiants as well. But the Law Commission said it would be possible to recognise belief celebrants, such as humanists, and independent celebrants. And that's where the Law Commission, in my view, then created a distinction which is slightly troubling. So the headline of the Law Commission's report, a move from buildings to officiants, firm tick from me, firm thumbs up. The detail, however, is slightly more concerning because it creates this distinction between civil marriages and belief marriages. And belief marriages would include religious marriages, it would include non-religious belief ceremonies such as humanists, but it wouldn't include independent celebrants. They would, if they were included at all, would come in under civil marriages. And so they would be treated in the same way as civil registrars. And that matters because the proposals would the proposals say that belief marriages, the officiants would be responsible through their organisation. So the organisations, such as Humanists UK, for instance, would be responsible for their training and for deciding who the officiants are. Whereas the independent celebrants under the Law Commission schema, they would have to apply individually. Now, to me, this makes no sense because there already are umbrella organisations protecting and regulating independent celebrants to various extents. Not a huge amount of regulation at the moment because they're not legally recognised, but that could change. So I think that distinction is questionable, but that's very much a detail. And so the important thing at the moment is to try and make sure that reform gets up and up through the political agenda, up that list, so to speak. And there's been some encouraging signs since the election of the Labour government. A number of questions have been asked in both houses of Parliament, and it seems, based on those answers to those questions, that the government is considering comprehensive reform. And I think this is absolutely welcome. The Law Commission report is generally excellent and shows there's a real need for reform here and shows that it can be done. It's been done in other jurisdictions. And so it's really important, I think, to continue speaking to MPs and members of the House of Lords to stress the need for this change and this fundamental change from regulating buildings to regulating officiants. As I say, when you then get to the detail of how you regulate officiants, I think there's real questions still to be asked there. And I think the line drawn by the Law Commission isn't the line I would draw. But nevertheless, that's a detail. So it was a pleasure to speak to and take questions at the National Celebrant Convention earlier. And I hope this video has summarised why reform is important and where we are now. Thank you very much for listening.